Ladies and gentlemen, now without any further ado, allow me to welcome on stage our speakers for the keynote session, Regulatory Rifles, the Rage Continues. For this, I would like to first welcome on stage the moderator of this session, Ms. Lakshmi Menon, Country Counsel, Hewlett-Packard Enterprise, India. Lakshmi is the Country Counsel for HP, India, advising on commercial transactions, general legal and employment-related issues, corporate and employment litigation, member of Ethics Council and Internal Complaints Committee. Prior to joining HP, Lakshmi has worked with Indicom Global Services as legal lead counsel. She has also worked with IBM, India, and Wipro in the past. Welcome, Lakshmi. Our next speaker to welcome on stage is Mr. Anubhav Kapoor, General Counsel and Company Secretary, Tata Technologies. Anubhav is responsible for Tata Technologies' global legal IP, regulatory compliance, and corporate governance practices and policies. Anubhav has over 20 years of experience. Before joining Tata Technologies, he worked at Polaris Software, Domino's Pizza, and Allied Nippon, to name a few. He's passionate about innovation and IPR, also heads the company's corporate sustainability and corporate social responsibility practices globally. Welcome, Anubhav. Our next speaker to welcome on stage is Madhu Shivaram, Head Legal Avaya India. Shivaram has over 15 years of PQE working in-house both with law firms and as a litigator. While his key expertise is transactional law, with a practice focus on commercial contracts, he also has significant experience in employment laws, licensing, compliance, and litigation management. Welcome, Madhu. Our next speaker to welcome on stage is Ms. Namrta Sudan, partner Dhir Dhir Associates. Namrta, over the years, has specialized in both IPR and corporate commercial practice. She has handled a wide mix of matters, including cross-border transactions, MOUs, labor and employment agreements, real estate agreements, and transactions relating to media and technology, telecom, and IT. She has also advised clients on regulatory matters and also on enforcement and protection of intellectual property. Welcome, Namrta. Our next speaker to welcome on stage is Pradeep Gupta, Company Secretary and AVP Legal, Compliance and Taxation, DPS Bank. Pradeep has over 12 years of experience in corporate taxation laws and regulatory practices, company secretarial compliance, legal, corporate governance, finance, and accounting matters. He has also appeared before tax and regulatory authorities with exposure to multinational corporate environment. He has built a niche in IT, ITES, BPO, KPO, and financial industries. Welcome, Pradeep. Our next panelist to welcome on stage is Mr. Subodh Prasad Deo, partner Sai Krishna and Associates. Subodh is a former Additional Director General of Competition Commission of India and has carried on investigations across various sectors for over 6 years. He took a voluntary retirement in 2013 from the government service to pursue his passion in competition law and has been since heading the competition law practice at Sai Krishna and Associates. He has extensive and niche practice in applying the enforcement provisions of the Competition Act in diverse array of sectors, including aviation, drugs, and pharmaceuticals, energy and infrastructure, and more. Welcome, Subodh. Now, Lakshmi, if I may request you to kindly take over the panel discussion.
India has been witnessing some very significant changes in the regulatory landscape, and this is, I think, one of the primary reasons why we see a very, very different and I would say there's a sea change in the way business is conducted in today's day and age. And it's not restricted only to the IT and ITES sector. I think it pans across various industries. And in this session, the speakers, the panelists here, we're going to discuss a select few areas in the regulatory landscape which we feel have definitely left some sort of an imprint on the industry. So we're going to expand upon a few areas such as the unionization of the IT and ITES sector, the consolidation of labor laws, some of the key changes in the Companies Act from a related parties transaction perspective, as well as on beneficial ownership. We're also going to talk about antitrust and anti-competitive agreements. With that, I think the first topic I thought would be interesting to talk about would be the unionization in the IT and ITES sector. So yesterday, one of my colleagues who's based in the South Pacific in Australia, he sent me a link, and he didn't give any subject title, so I just out of curiosity opened it, and it had an entire article on pictorial contracts and pictorial employment contracts. With all the innovation and I would say developments taking place in the field of employment, I think employment has become something which is much larger than the company that's employing the employee as well as the employee itself. So we see that, I think a week back, Australia recorded one of the, that one of their companies, an Australian company, had gone ahead and launched pictorial contracts for their employees so as to ease the whole process of understanding how an employment contract works. And one of the key reasons why this move was taken was also because a lot of employees feel that the way employers draw up terms of employment are very onerous, it's not very transparent. And as you would know that there were recent layoffs in the IT and ITES industry a year back, that in turn has, and the spate of those layoffs also led to certain controversies in the way those employees were laid off. And this in turn has triggered an entire trend of having unions come to the fore. And the Labour Commission in Karnataka in fact has now allowed for IT companies to form and employees to form their own unions. So with that, I would sort of turn it over to Namrta to comment a bit about how the IT industry has managed to remain insulated till date from the entire unionization.
Before we talk about this, Lakshmi, I'll quickly give us a snapshot of basic regulatory framework. So Article 19(1)(c) of the Constitution of India guarantees freedom to form trade unions. In fact, there have been many judicial precedents where formation of trade union has been upheld, and also there have been a lot of encouragement to indulge in collective bargaining to resolve disputes between management and union. Although registration is not mandatory, but it does confer benefits. Such as you can enter into a contract, you can sue, you can hold immovable and movable property, you are immune to certain contractual, criminal and civil proceedings. So far in the IT sector, ITS sector, because of the mass retrenchments and layoffs, there was a lot of unrest. Employees, and most of the retrenchments were looked at as arbitrary, not judicious, or not, they were not. So, so Karnataka IT-ITS Employee Trade Union, which is called KETU in short, was officially registered on 7th November 2017, and it's under Trade Union Act 1926 and Karnataka Trade Regulation. After there was a clarification which was issued by the commissioner himself that IT-ITS employees are covered under the TU Act, because there was a lot of confusion whether IT-ITS employees are covered under the definition of workmen under the TU Act as well as under the ID Act. So there was a lot of, there was a little bit of gap there, and also IT-ITS sector enjoys a lot of exemptions. For that matter, just to give an example, industrial employment standing orders is one of the labor legislation which provides for employer creating a uniform service code by way of standing orders, which is required to be approved by the employee representative and also to be certified by the Labour Commissioner, which broadly provides for the service condition, wages and holidays and retrenchment for that matter, terminations. But since IT-ITS sector in particular in the state of Karnataka is exempted, and this exemption is going to get over on 24th January 2019, so the employers were taking, some of the organizations were taking advantage of that grey area and were terminating or retrenching mostly employees on evaluation, performance-based retrenchments were coming up. So that created a lot of unrest. So there was no voice to address their grievance. And there was also apprehension that these young ITS engineers are very young graduates, and they don't want to spoil their future prospect if they would want to really challenge their termination in a court of law or challenging their employers. So keeping all of those things in mind, it's actually after a lot of deliberation, although I would say that there were a lot of unorganized, unorganized unions, but they were never recognized. So this is one of its first, and it will have its own positive or negative impact. I think this is probably one of the key reasons why there was, there was a roadblock why this trade union, specifically in the IT sector, could not come up very soon. So now that it is in place, the industry will see a lot of changes. Of course, there will be positive and negative impact. Positive impact for employees being that there will be fair job creation. There will be some kind of job security. There will be very termination or retention will be on a very fair basis. Will be more transparent. The negative impact could be that it may impact job creation. Employees will be very, very cautious in hiring employees now that they know that there is trade union to address their grievances, and employees have to, especially GCs for that matter, they have to be advising or looking or advising their HR people. They have to be very careful. They have to create a complete roadmap. Now, instead of hiring too many employees, it's better to hire or then kind of lay them off later at the time of downturn. It's better to hire employees in a very systematic manner, in a more transparent manner, and following the due course of law when you're firing them or when you're retrenching them. That's the only I think that is where most of the disputes or grievance, so to say, arises when they are not paid their dues, or their grievance is not appropriately addressed in a more transparent or judicious manner. So I think we still have to see a lot of changes in the ITS industry with Key 2 coming in place, but I'm looking at I am being very positive. So let's see.
Okay, over to Anubhav to know more from industry standpoint.
Sure, I think you touched upon a lot of a number of important issues that are there, but I'll step back a bit, right? Because since morning, I think Mr. Lalit Bhasin and Mahadevan touched upon the real issues, right? So let's first understand what's going on in this IT industry at this point, right? And one of the studies at Forrester said the GCs have the top 3 items on which GCs have spent most of the time in last year has been data protection, cyber security, and compliance. And I have spent more time with my CIO and CISO in the last year than I had spent in 25 years of my career, right? So having said that, it goes without fail that this is the future, this is how the industries are going to be run, and legal departments or GCs will not be spared from that effect. If you are in a IT industry, you are in middle of that, but even if you are not in a IT industry, you will not be spared, because GDPR doesn't apply or privacy acts don't apply as per sectors. That's point number 1, right? So the other important or development or recommendation which was made in the Uday Kotak committee was that fraud management was highlighted as one of the risk management was highlighted as one of the key focus areas. Not only for the listed companies, they wanted to start with the listed companies, but then slowly they want to kind of take it to all the larger companies. And that is again one of the subjects that they defined the small company in the Amendment Act. But the point there was then he not only said that the company should have robust internal audit systems or internal control systems, it should have a fraud framework, but the third important point that he touched was there should be a cyber security committee. Now that underlines the importance of this subject across the industry, right? Now, having said that, what is actually going on in the IT industries is two things. One is the whole randomness at which the companies have been taking decisions of laying off and hiring. And believe me, it has nothing to do with the Indian legal environment. Everything it is to do with because of the whole globalization of the industry itself. There is someone taking a decision in US that affects the Indian operation, the Indian company or the US operations, the effects are felt here in India. If there is a change in the visa regulations, the effects are felt here. If there is a Brexit there in England, the effects are felt here, right? So the decisions are not controlled by the Indian legal system, or it is much more deeper and evolved now, right? And that has led to a certain confusion with the ranks and files within the IT industry. And believe me, IT industry is no longer a small industry in India. The last count was in Bangalore itself, there are 1.5 million people who are associated directly with IT industry. And across India, the numbers go beyond 5 million. So it's become a large industry, and Namrta touched upon very nuanced sides of it that many, like for example in Pune, Hinjewadi, we used to we were neither under shop establishment, neither we were under Factories Act, because Hinjewadi was a Gram Panchayat area, and the last Shop Establishment Act kind of said the Shop Establishment Act will be applicable only in the notified area. That situation has changed now with the new, and here is a company, or here are a group of companies like outside Bangalore. I think Infosys and Wipro have their largest bases in Pune. And imagine a company or companies deploying 10,000 or more people, they are neither under Companies Act, nor shop and establishment is applicable. Where does the employee go? Correct. If he has to seek a redressal, where does he go? Does he go to the ethics committee of the company? There are mechanisms like whistleblowing available, right? But the HR departments have now devised very, I think, fluent policies like PIP. I think everyone knows PIP very well. So the appraisal cycles have been reduced from an annual to almost quarterly now, right? And the decisions of hire and fire are being taken at a speed like never before. So what is the effect that leaves on the ranks and files and the employees? I think it is but natural that the whole employee activism that we are seeing in terms of unionization, because these employees need to go and find some recourse, right? Because at the end of it, it is their livelihood. Part, they are not understanding it. Second, there is no effective way they can redress their concern. So it's very automatic that this whole unionization topic is becoming very central. Karnataka is the first state to kind of really recognize the key to or the IT employee unions. But in other states, the things are similar. We don't have unions, but there are pressure groups that are being formed. The traditional trade unions are increasingly active to mobilize pressure groups for the IT industry, because that's what is creating the transformation in those cities. Cities like in Pune, cities like Mysore, cities like where the IT spawning has taken place, Gurgaon. All this, there are pressure groups. And rightly so, Namrta pointed out, the employees, yes, they want a recourse, but also the companies have come together to find out situations where these things are not effective, because nowadays there are a lot of background checks that are being done. There are a lot of referral checks that every time you go and apply for a job, there are 2 references, and people do call them, right? And there is this whole concept of relieving letters that is being now agreed almost as a soft mandate by all the companies. So it is making employees hesitate to get recourse. But at the same time, there is this whole undercurrent that where do we go? So I think this is again that whole, the whole context that is forming in a larger industry, that this topic is becoming relevant, but at the same time, it is still at a very toned out level. It's not the mainstream concern I would have, say, for my company. But the second or the more relevant part of apart from this socio-political developments is the whole automation part of it. The automation part of it, the speed at which AI and the automation is being talked about, I believe it will be faster than we think it will be. There is very tangent proofs of concepts that are being experimented, and things will be much faster than we imagine, which leaves us with this whole scare of reskilling, large scale unemployment. The headline news, I think media is taking its own dig on it, that India story is out. This again is kind of creating a nervousness among the employees. Of course, they are trying for reskilling, but at the same time, how can hiring and firing be so easy? How can people be just let go? And part of the GC's problem is the whole social media. Now we have terms like rogue employees, social media management, things like that, but which are not there, as Mahadevan said 10 years ago. We are all dealing with that every very, very often on that. So that was my 2 bits on the unionization trends that are there. But I think IT will be a very potent area now for these subjects, because the activism is going up. And leave alone the employee. The shareholder activism is also on the rise, though we have many avenues on which shareholders can exercise their rights, but I'll cover that later.
So, Madhu, from your perspective, what do you think is like the road ahead when it comes to this entire field of unionization? And what are the challenges you see with this trend, coming into play?
So I think, thanks Lakshmi. So I think my fellow panelists have already eloquently addressed the topic very, very well, right? So obviously I think a couple of things that come to my mind when it comes to this increasing unionization, right, is obviously the lack of transparency on the part of the management, to a considerable extent, I would say, or maybe a limited extent. And obviously, the lack of, I would say, that strength in our labor laws. Right? We do have a plethora of labor laws, but I think, let's face it, as in-house counsels, I think we have advised our management how to tweak our laws to effectuate terminations and so on and so forth. So I think it is extremely important for the companies, especially in India, right, to strike a balance between business promotion and employee welfare.
Yes, that's
right. So obviously, a little bit of transparency is absolutely called for. And I think, Anubhav, you touched upon a very important word, PIP, right? Because PIP is something which is, I think it's hardly used in most companies, right? Because I recall countless conversations with my HR where I asked why a certain individual or group of individuals have to be let go. They say that due to performance issues. Then put them on PIP. No, we don't want to put them on PIP. It'll take a lot of time and effort, right? Then what is the purpose of a PIP? If you're actually trying to let go of a person purely on performance grounds, right, then you really must leverage your PIP program, right? So again, that is just one tool of abuse, right, which is predominantly used by most companies. And this has been going on for quite a long time, right? So I think maybe this unionization is actually, I would say, that stem from some of these, I would say, that abusive practices, right? But at the same time, we have to be realistic enough to accept the fact that we have to run the business, right? So some of these global, I would say, that factors that find reflection here in India on the ground, right, would definitely lead to, losing of jobs, right? There could be automation also that would be instrumental in these job losses. So I think at the end of the day, I think managements or the companies have to strive and arrive at some sort of a balance, right, in achieving this, overall objectives, business and employee welfare. That's my view.
So, Pradeep, do you want to add on to what
Yeah, so I
Sriram
can,
said?
I saw my panel speakers have already covered enough. So I can, just want to talk about the IT. IT industry has been a sunshine industry so far. So which is almost contributing more than 7% of the GDP, and then adding a revenue of more than $160 billion, and then giving employment to, I think, more than 11 million direct and indirect employees. So having this background, right, so why this unionization has not happened? Because of this IT employees, there's always been a crunch of talent. There's always been a crunch and the shortage of supply in the market. So even if somebody has or the other has been wrenched off, they have always been finding the jobs in the market. So, and the second is they have already been treated very well. They are the well-traveled lot, right? And then they're already been the well-traveled lot. And then whenever they lose the jobs, it's very easy to find the jobs. So that's the primary reason there has not been much unionization happened so far, even after the 20 years of the IT involvement of the IT industry. So maybe primary reasons that it is being happening now is, as Anubhav just talked about, is the AI and the automation. And just to add on what my colleague Madhu just said, in addition to the balance, we can also think about the planning, like Namrta talked about, planning when it comes to the hiring and the business plans. So that is the one.
I mean, you will see a lot of changes in the employment agreements as well, and also their offer letters, also even in company policies. Madhu rightly said, even Anubhav said, we must focus on employee welfare as such, so that there are lesser disputes and the machinery can be run smoothly.
But after this trend,
sorry.
no, I didn't mean to interject. But after this trend has begun, do you all see in your respective organizations a change or a change in the perception of the employees as to how they can escalate matters or how they can bring things to the notice of the management? Is that something that you see?
I don't think there is a clear answer to that. It will always be which hat you are wearing, right? On one hand, I think the systems related to whistleblowing, systems related to ethics counseling, they have on the increase, right? On the other side, the companies, the last suggestion, why don't you explore arbitration clauses in your employment agreements, right? Especially for key hires or senior management, because it will be a lot more easier with all the recent controversies around CFOs and GCs leaving. It will be much easier to handle that without the public limelight. So that's increasing as well. And then this whole notorious bell curve, we have to face everything. So imagine an employee who has been told by his project manager, you are good at your project, and suddenly when the appraisal cycle comes, he said, oh, you are no good, you are let go, right? He said, I scored A last year, you gave me an employee award a month before, you are asking me to go? Yeah, that's what the bell curve says. So this kind of a HR environment, where is the human to human resources, right? Obviously, the people are going to kind of vent out their anger and frustration in one way or the other, and unionization seems to be one way of doing it, though I don't think in IT industry with the pay scales and the level of they don't qualify as workmen. So maybe we have to relook at the whole laws, maybe a special set of laws for IT industry, I don't know. But right now, many of these IT companies enjoy, because of the scale of their pays, they go out of the net of the labor laws, right? So that's kind of a tool which is very effectively used within the IT industry. But that's the reality. I think this struggle is going to go on, and we have been seeing some cyclicity in terms of unionization as well. 70s and 80s saw rise of labor union, then I think the economy opened up, unions faded away, the leaders faded away, and then I think it's a cycle of 20, 25 years, and it is about 25 years now since we saw the last union trends in the country. So I don't know, future is anyone for predicting, but at the workplace we are seeing that whole dynamics playing out.
Yeah, so I think from my experience, I think yes, people are talking about unionization, but I think the IT sector per se, I'm reasonably sure we are still some distance away from this getting crystallized, right? Because obviously, because of the primary nature of the IT sector, even though I would probably differ with the view that IT people are not workmen, right? Because the jury is still out there, right? So I feel that depending on your roles and responsibilities, you might still be considered as a workman within the ambit of ID Act, right? But that being said, yes, people are talking, but again, because of the very framework within which ITS companies work, not many people would be, would have that inclination to actually go ahead and form unions, right? Yeah. While still being employed with the company and so on and so forth. Yes, but in terms, as far as speaking up is concerned with respect to these kind of so-called unfair labor practices, so I think the only law I've seen that is going to have a major impact for the last few years has been the POSH Act, right? So people are speaking up, right? But with respect to other sort of areas of unfair labor practices, from my experience, I don't see very many voices coming up, right? The trend may change, but I think it is incumbent on all management, I think, to be transparent to the extent practically possible. So, I mean, let's face it, you can't be transparent all the time, right? So there are certain business exigencies that actually sort of compel you not to speak your mind, right? But at the same time, there has to be some fairness in the policies, right? To
at least ensure that the workmen dues are
yes,
paid.
Exactly.
So there is
and also, if a person or a group of people must go because of genuine retrenchment compulsions, be very open about it, right? So there is no point in beating around the bush, bringing in performance indicators when there is none, right? So obviously you have to be as open as possible. I mean, there's nothing wrong, because I think employees these days are also mature enough to understand that, right? There may come a time where they will lose their jobs, right? So nothing is permanent, right? So I think you have to be as open as possible, right, when it comes to these type of conversations, right? So I think abusing the performance factor to eliminate a position, which is what most of the companies here in India tend to do, and that has to stop, right? If those activities, those actions don't stop, perhaps we will see more of this unionization activities.
Anubhav is going to look at me with those eyes, but TCS is a classic example where there was a report, a committee report, which actually concluded that this was being misused.
Yeah. See, there are a lot of examples, Namrta, the Tech Mahindra public apology case, there are a lot of, but the point still is they didn't rely on the letter of law, they didn't rely on the law. That was more of emotional management or social media management, right? It was just that the flows happened in one direction and things changed, but where is the law? Which employee can stand up and say, you can't fire me like that, right? You have to give me an opportunity to hear. You have to be rational with me. Where is that law? And I think that is what is required for IT. Now, with the larger scheme of labor laws, with so many industries, I find that we have lot of gray areas right now, which are being used or misused, as the case may be. But companies who are giving a fair deal to their employees, they are not having any problem. They have a smooth ride. It's just that misuse, or when people feel hurt about it, that's the problem.
Sure. So to close this particular topic and move on to the next one for the panel.
In such a situation, are you implying that the company would probably think about not giving or extending the legally entitled benefits? Is that something that we can do?
No, so usually employees like this would claim, I think, make their insurance claim post being let go of. So they already claimed their severance and they've moved out, and then they're claiming insurance, right? So so the question is, so this is exactly, you know, something that I'm sitting and debating with my HR team. You know,
very good point.
Should we be asking employees who we are letting go of as to whether they have an insurance policy in place against job loss? So yeah, so it's something new, completely new, which has emerged, and it's completely a fallout of this trend, you know, where people are being laid off, and there's a lot of uncertainty in the job market. So anyway, with that, I'm being told that I need to, you know, sort of get moving with the rest of the, you know, topics. So Anubhav,
Lakshmi, can I excuse myself?
Oh, sure, sure. So Anubhav has to, you know, leave our panel because he's got to catch a flight. So thank you so much, Anubhav.
Thank you, Anubhav.
Thank you so much for having me here. It was a pleasure interacting with all of you today. Thank you.
So with that, we go to our, you know, our next topic. Here we're going to speak a little bit about antitrust laws, right sharing, and I would like to start with Subodh, because Subodh works extensively in this area. So would you like to walk us through some of the current trends?
Yes. So talking about unionization and leap forward in technology, which has left the regulators and the legislators actually in the lurch, and they really do not know what to do. I think none typifies this better than ride sharing and ride sourcing platforms, which are popularly known as the cab aggregators. So as we all know, in 2010, Ola, a domestic cab aggregator, surfaced, and in 2013, a global cab aggregator, Uber, came into existence. And the legislators were wondering, and the regulators were wondering, whether they are intermediary platforms which provide a platform where the drivers and the users meet, or they are basically transport companies. And this central question, I think, is linked to multiple issues. The rights of whether the drivers are employees and whether they have the rights that are available to an employee, whether the drivers are independent contractors, and therefore there could be collusion because independent parties join together and fix a price which is uniform across, there is no competition per se. And this is related to a whole load of questions, not only in India, but in US alone, I think more than 70 cases have been filed against Uber on various issues, right, ranging from labor disputes to antitrust to so many things in Europe and so in India. The first challenge that we saw in the country was when a lady passenger was molested sometimes in 2014, and the question of ascribing liability arose. Who was liable? Whether it was Uber which was liable, whether it was the driver who was liable for whatever happened in that vehicle. Be that as it may, I think the Ministry of Road Transport and Highways came up with some guidelines which were non-binding, and this is a subject which is a state subject, and therefore the state governments have the primacy over whatever laws they have made thus far. And then several cases got also filed in various courts in the country, and the Delhi High Court also issued certain orders. Thereafter, the ministry once again came up with a guideline, and in that guideline, they defined these cab aggregators as transport services. Now, whether they were actually transport services or whether they were intermediaries was, in my view, largely perception based and largely not based on any empirical research and study as to why they would qualify as a transport agency. Perhaps that was easier because the transport regulation law already existed and it was much easier to sort of rein them in. But the efficiencies that got lost in that process, was something that they really did not look at it. And so the cab aggregators got defined as transport agencies. Their fares got regulated, not more than 3 times of the day fare. Maximum surge pricing got regulated, not more than 4 times for the night fares, etc., etc. happened. Several cases got filed in the CCI also by the traditional taxi platforms. As many as 10 cases got filed on the ground that they are indulging in predatory pricing, which means pricing below cost, because the investors, global investors are investing, pumping in money, and these guys will become dominant, they will eliminate people, and thereafter they will recoup these losses. Similar cases have also been filed in US and in Europe. Now, the Competition Commission of India, in my view, has done a fantastic job thus far in handling these subjects. It has closed almost all the investigations. In fact, it did not even order an investigation in most of the cases. It did order an investigation in only one of the matter, which pertained to Bangalore, where Ola was held to be dominant because of the market share. But the CCI, in its opinion, while closing the case, did not consider Ola to be dominant on the ground of having the largest market share. Because it says this is a market which is a multi-sided market, and it has network effects. And these multi-sided markets and network effects, as I'll just explain, cannot really be assessed in terms of the market share that an incumbent holds as of now. And it has to be seen in terms of what are the external advantages or disadvantages, what are the entry barriers in the market, what is the level of competition, what are the competitive strategies being adopted by the competitors in order to determine whether or not a particular entity is in a position to determine and control the prices in the market. Now, so it basically decided that, and in fact, it commented also that various state governments have. So let me just explain. There is no law as such which defines the cab aggregators as transport agencies. There is only certain guidelines which have been issued. Those guidelines are not mandatory, and there was a bill which was also moved before the parliament. That bill is called the Motor Vehicles Amendment Bill 2016, but that bill is still before the parliamentary committee, and the parliamentary committee seems to be saying that the central government should not have a primacy over the legislation in this field. It should be left to the state government. The subject is still very much fluid, and we really do not know. Now, to explain the competition concerns, in USA, a very famous case known as the Meyer versus Kalanick. Kalanick was the ex-CEO of Uber, and a case was filed by one of the user of these services, Mr. Meyer. He said that this is an antitrust price fixing conspiracy. And the allegation that he laid was that Uber has entered into an agreement with independent contractors. All these drivers own their own fleet, their own vehicles, they are independent contractors, but they have all joined hands together through this intermediary platform to create a common platform for everybody. And whether that price is fixed in a manner where there is no competition, whether that immediately benefits the consumers or not, is immaterial for the purposes of competition law, because competition law says that prices have to be unilaterally determined. Whether the prices are low or prices are high is immaterial. The fact is, how have the prices been determined? And these guys, Mr. Meyer put this claim in the New York District Court in 2016, where he said that these prices have been fixed. Uber organizes camps for drivers, incentivizes them, trains them, takes their feedbacks, removes them, etc., etc., etc. And therefore, so Uber and these people, Uber and these drivers have joined hands together and have indulged in an antitrust price fixation. Of course, in the appellate court, this case was not considered on antitrust ground, but it was remanded back for arbitration. And similarly, there have been cases in Philadelphia, in Seattle, where the state government of Seattle, they gave powers to independent contractors. So employees already had powers to unionize. Okay, employees already had powers to unionize and demand whatever they wanted from their employer. But Seattle gave this power to independent contractors as well. So all the independent contractors working for Uber, they were given this power to collectively negotiate the terms with Uber itself, or whatever their employers. This basically went into appeal in the higher court, and the Department of Justice and the Federal Trade Commission both filed an amicus in this particular matter. And in the amicus they said that irrespective of the benefit that such legislation is likely to bring to those independent contractors, this will be treated as an antitrust per se violation for collective bargaining by people who are separate economic entities. So all drivers were treated as separate economic entities, And because they were separate economic entities, they could not collude with their competitors, which means other drivers. And if they did so, under the garb of collective bargaining, they would constitute a price fixing cartel. And that would tantamount to, so we really do not know what is going to happen in this. Now, another development that has happened is in the European Court of Justice. In the European, which is the apex court of Europe, what has happened is, on a reference from the National Court of Spain as to how should these, be classified, these ride sharing and ride sourcing platforms be classified, whether they are intermediaries or whether they are transport services. And different jurisdictions have given different opinion on this, and therefore to harmonize all that, they went up to the European Court of Justice. The European Court of Justice, after taking opinion from the Advocate General, they have come up with a detailed order. And what they are saying is, to the extent that they are providing the intermediary service, they ought to have been categorized as intermediary services. But the platform is not the main activity. Platform is supporting an activity which is the transportation activity. There are several terms and conditions to which these drivers are bound, and all these drivers have to adhere to those terms and conditions on which the platform exercises a decisive influence. Okay? So what they said, that the platform services being provided is not an independent activity and is not, and the latter activity, which is the transportation service, from where revenues also come for operation of the platform services, is the main activity. And therefore, they clubbed these together and said that they should ideally be categorized as transport services. Okay? And of course, they have left it to the national governments in Europe to sort of basically frame their own national legislation as to how they are going to decide. Now, to sum up the whole matter, because we have very little time, two observations I simply want to make. One observation is that while we deal with, see, technology always changes faster than relations of production and your existing legislation, because technology is one that impinges on the legislation, and legislators are then forced to change that legislation to comply with what this technology is demanding. I think we are at the cusp of that situation, and as I saw my previous speaker speaking, it seems that there is a big hiatus between what the regulatory landscape is and what the actual reality in the market is. And I would really commend the Competition Commission of India for really not precipitating a decision, and instead saying that no, this is a market that needs a deeper study, and it has commissioned a study to understand how these network effects are playing, because a new, whether there are entry barriers, a new entrant would first require drivers, and if that platform becomes popular, it's only then that the users of that platform from other sides, this is the other side, multi-side, they would be able to come. All drivers and users have multi-homing capacity. That means you can switch on from an Ola to an Uber and things of that sort. Whether there is some kind of exclusivity, whether there is any restriction being caused. So unless until we study these empirically, I think we should allow technology to take the lead. But politicians have different requirements. They have to meet the requirement of the population, public reaction they have to take into account, and they come up with some kind of knee-jerk reactions which doesn't really help. And I think the lesson for us today is, in my understanding, the lesson is that we need to study the subject more deeply in order to bring a proper legislation. Because if you interfere with technological innovation, then what you are going to do is basically, for instance, surge pricing. We all are affected by surge pricing, 3 times, 4 times prices increasing. But understand, surge pricing in itself may not necessarily be anti-competitive or excessive in prices, because we really do not know what's a fair price. So long as there are consumers who are willing to pay, their requirement is met. Drivers are incentivized to come to the market, they would come. Now, assuming that the prices did not go up, those drivers who were taking rest at home would not be lured enough to come into the market and increase the supply. We need to study the ramifications of these kinds of interactions between technology and legislation in order to bring about a change. And I think this is an area which we will see further developments in the coming years. Thank you.
Sure, thanks. Yeah. Thanks, Subodh. Yeah. Very insightful. And I'd just like to request Madhu also to talk a little bit about, the abuse of, dominant position and what the CCI's, recent decisions are, and, what have you seen, as interesting trends here?
Yeah, so I think, I completely agree with Sumo that CCI has done a fabulous job, ever since its inception in 2009, 2010, that time frame. So I think some of the key takeaways from some of its landmark rulings, obviously the latest being the Google one, right, is obviously I think there is definitely an endeavor, an honest endeavor to create a level playing field, right, for all kinds of players, right, small, major, minor, and all, right. But that's on the face of it. But the reality is that, this so-called the Goliaths of the world will certainly try and rewrite the rules of trade, right? So in spite of the best endeavors of our antitrust regulator, one of the sad realities, I was actually shocked to hear that statistic, read that statistics. Like for instance, ever since its inception started ruling, right, against anti-monopolistic practices and all, it has actually imposed penalties to the tune of almost 14,000 crores, right, to date. But it has only managed to recover less than 100 crores, right, which means that so all those initial judgments are actually getting wallowed in appeals and those kinds of processes, right? You take this latest Google judgment, for instance, right? It's interesting that, yes, that the CCI definitely came hard on Google, right, in finding it guilty of search bias, right, and also imposed a penalty of maybe just over $20 million, which is small change as far as Google is concerned, right? But if you read that judgment, even though I did not read it verbatim, but I just got the drift of it. There were in total 12 counts brought against Google, right? And it was actually found guilty of only 3 counts, right? Out of these 3 counts also, some of this so-called search bias, which was actually alleged against Google, they actually ceased that activity, so-called abusive practice, way back in 2010, right? So obviously, I think there was definitely an effort on the part of CCI, right, to kind of curb down, to clamp down on market abusive practices. But at the same time, they also did not want to stifle innovation, right? The other way of looking at it, I'm not too sure, this is my personal view, whether our antitrust regulator is robust enough to handle technology kind of issues, right? Maybe that's one of the main reasons why, unlike the European Commission, right, last year, which actually slapped a penalty of nearly $3 billion for more or less the same kind of, issues, search bias last year. We just imposed just over 20 million on Google, right? And obviously, Google being Google, they're going to appeal it, right? So the question is, when are we going to get that money? So are we really setting all these judgments, all these rulings, are they really setting a deterrent, framework in place? To me, no, right? Because I think it needs to have a lot more teeth. Maybe there is something lacking in the evidence stage, because at the end of the day, most of these judgments have to be based on evidence and rules-based, right? So obviously, I think there is a school of thought that, especially with respect to this Google judgment, there were a few dissenting voices also, right, within the commission. And one of their contentions has been is that most of these findings, right, even on these 3 counts, have not been based on evidence, strong evidence. So the likelihood being, I think the message being sent out is that Google is likely to emerge victorious in appeal, right? So I think over the years, they have come up with really path-breaking judgments, including, I recall there was one in 2012, which was, spread across the papers also. It was a lone individual taking on the cement lobby, right? And there was a huge penalty being imposed, close to 7,000 crores, right? And 6 years down the line, none of the money has actually reached the intended recipients. It is still being stuck in appeals, right? So I think, yes, there is a noble endeavor, there is maybe, a good intention effort on the part of CCI to create a level playing field, but the reality is a little different, in my opinion.
I know you have your time constraint, and you have been getting late. I just want to make one quick sort of comment on what Madhu said. I think one thing, I don't hold any brief of CCI any longer because I'm no longer a part of that, but I just want to make one comment. Now, CCI is not a leveler of competition. Let's understand this very clearly. Many people say that there are small players and big players and everybody. It's not a leveler. See, the given inequalities already existing in the market, CCI has no role to equalize that. Let's understand that very clearly. What it ought to do simply is, so we have also migrated from the monopolies era to the competition era. Why? Because you can become a monopolist today and it would not be offending the law. That's what the new law says. And the law was changed because we wanted companies to become really dominant companies and monopolistic companies which can compete on a global basis. Otherwise, we had already the Monopolies Restrictive Trade Practices Commission Act, which was sort of suppressing monopolies, because of the socialistic pattern. The point that I'm trying to really make here is, the job of the CCI is to see whether competition is being thwarted in the market or not, whether entry barriers are being created, whether foreclosure effect is happening in the market or not. And if that does not happen, then whether you are big or you are small, you have absolute freedom to do whatever you feel like doing. And the other issue about penalty that you just mentioned, Madhu, these are high-stake cases. Penalties run into 10% of the gross turnover of a company, which is a huge amount. And all these, our courts take time, and all these cases, you will see this year, many cases will be decided finally by the Supreme Court, and eventually you will have to pay the penalty or people will go to jail. It's as simple as that. So penalties will come. It's only the time that is being taken in judicial decisions why penalties are not getting recovered as of now.
Okay, thanks so much. Since we're running out of time and we're going to have a networking break right after the session, if you have questions for the panelists, I would request you to sort of reserve your questions till you'll all step out. Thank you so much for being such a great audience, and thank you panelists for sharing your insights. Yes, sir.
Just an observation, not a question, but firstly about the Competition Commission of India. I think they had no option, you see, because they did not even order any investigation, because it was not on the face of it ex facie anti-competitive thing. Therefore, and it is premature, because above the Competition Commission there is the appellate tribunal, above the appellate tribunal it is the Supreme Court. But I would just like to comment basically on the first part of your session about the labor laws. Yeah, we have too many laws, overlapping laws, yes, outdated laws, and a need is to rationalize the laws. But trade union is not just a trade union of employees. A trade union can be a trade union of employers also.
Sure, sir.
And not just confined to workmen, it can be of officers also.
Sure.
So therefore, one need not be afraid, you see, if some trade unions are being set up. What has to be seen basically is the definition of workman.
Workman, that's
workman, there are three decisive criteria now laid down by the Supreme Court. Firstly, it is whether they have a supervisory role. But more importantly, whether they have the power to take decisions, which decision will be binding on the employer, that is the company. Thirdly, a person may not have supervisory role because he is working on his own. Therefore, that intellectual activity part of it, you see, will also not make him a workman, will take the person out of the definition
Absolutely.
of workman.
Absolutely.
And then, when you say that Karnataka has got certain exemptions, exemptions mean that the acts do apply, but the government has given exemptions, you see,
Sure.
with regard to that. No, just let me finish, please. Now, Shops Act has got so many provisions, like closed days, break hours, lunch hours, overtime and all that. I think there is a need for the industry, IT industry, to come together and ask for a specific code, you know. I have been advocating a separate labor code for the hospitality industry, because you can't compare a hotel like this, you see, with some factory which is manufacturing so many goods and items. IT is a special industry, special services activity. There should be a separate code. You people allow your employees to take work home. Now, when they take work home, where do you judge, you see, how do you analyze how much working hours he has put in? So there could be claim of overtime. You say, I spent only 3 hours in the office, but I spent about 9 hours, you see, at home working on the same thing. These issues have come up. I'm telling you with my own experience. Therefore, what needs to be done is to have a rationalized approach that these labor laws would not, by very nature of things, apply to the IT industry. So a common voice has to be raised, and not just at the state level. I think make it an all level. And the fixed term contract, someone spoke about, you see, about the Industrial Employment Standing Orders Act. Even without that, because that act applies only to industrial establishments. Therefore, the first test would be whether you come under the definition of the industrial establishment or not. But more importantly, fixed term contract is already recognized under the Industrial Disputes Act. A definition of retrenchment itself says that a fixed term time contract will not be inclusive in the definition of retrenchment. So it is not an anti-labor practice. It is recognizing the needs of the hour. It can be either project-related work. If you have BPO, you know, some assignments are given to you, you finish that project, therefore the contract will come to an end. Or it is a fixed term contract. So these are issues which are common, and I think you need to take a common stand on that. Thank you.
Thank you so much.
Thank you very much, Dr. Bhasin, and thank you, esteemed panelists, and thank you, Lakshmi, for that wonderful moderation. Ladies and gentlemen, due to paucity of time, we will break for the networking break now, and apologies that we couldn't do a Q&A, but of course, the panelists are available over the networking break for this. Lakshmi, if I may request you to kindly felicitate our panelists. Starting with Madhu Sivaram. Not name specific. Namrta Sudan. Pradeep Gupta. And Subodh Deo. And if I may request Ms. Poonam Rawat, CEO Dhir Dhir Associates, to kindly come on stage and felicitate our moderator. Can we have the panelists back on stage, please? We would need a group photograph. As we wrap up with the group photograph, ladies and gentlemen, let me remind you about the feedback forms. Please do keep filling them out through the day and hand it to us organizers before you head out for the evening. We'll now break for the networking tea and break, which is available in this room itself, right in the back, for your convenience. And we'll reconvene for the next session at 12:10 p.m. sharp. Thank you.